The issue of female judges has existed since the formative period of Islam, inspired largely by prophetic traditions preventing the authority of women. The issue arises mainly from the authority granted to women in such positions and how this affects the authoritative power of men in contrast. The Qur'an and Hadith within the Islamic faith contain numerous statements that place men at an advantage to women when it comes to dominance and power in the public sphere, stating either the inaptitude of women or the superiority of men in positions of political, public, and religious leadership. Though modern religious authorities will be quick to claim that this does not exist on a spiritual plane as it relates to God, the authority of men, as evidenced by religious scripture and tradition, plays a substantial role in the lives of women and the capacities they can fill in society. Welcome to another episode of The Religion Inquirer, a channel dedicated to investigating religious thought, history, and influence, classically and in more modern times, with in-depth research into academic publications and opinions in the fields of theology, philosophy of religion, and religious law. Without further ado, let's dive in and explore the topic of the issue of female judges in pre-modern and modern Islam. Though discussions surrounding women in positions of authority, such as existing within a judicial capacity, existed since the formative period, the debate on the issue escalated in the 5th century amongst the competing positions found in the different schools of law. In this regard, the Hanafi, Lahiri, and Jariri schools supported the practice of women as judges, with virtually all other schools being against this appointment. Although there exist dissenting voices within their respective schools, most scholars of a particular school tend to agree with the opinion of their school. For example, the Shafi'i Ibn Abi Dam disagrees with his own school's view, while maintaining the position of the Hanafi school, which is that women can serve as judges in the same areas of law in which they can serve as witnesses, which includes every area except the hudud and qisas, which make up criminal cases. In terms of an unqualified appointment, At-Tabari, the founder of the Jariri school of law, is the only known proponent of women judging in all cases, his reasoning being based on the fact that women act as muftis, which he considers within the same analogical category. Muftis are religious authorities who make non-binding religious verdicts and have high levels of religious knowledge, which they use to make their judgments. From the opponent's point of view, this capacity to serve as muftis involves the issuing of verdicts which are non-binding, as stated earlier, for a reason, and can therefore not be used to fortify the argument for the appointment of female judges, given that judges carry greater weight in their decisions, which are enforced under state law. This argument, the argument surrounding the position of authority, as stated earlier, is the basis for the rejection of women judges. To substantiate their claim that women cannot serve in positions of authority, an oft-cited hadith is the hadith of the detrimental effect of women's leadership in a political capacity. The hadith is found in the hadith collection of Bukhari, the most trusted Islamic source after the Qur'an, where the Prophet Muhammad is reported to have said, "Never will succeed a nation as makes a woman their ruler." This hadith, in combination with Quranic passages to the same effect, such as verse 434 of the Qur'an, which states, "Men are in authority over women because God made the one superior to the other and because they spend of their property," serve to solidify the interpretations that evaluate men as serving an authoritative capacity over women within both private quarters of the home and the public sphere. To further substantiate this innate inability in women and prescriptive mandate for men, scholars also use the hadith which states that women are deficient in intelligence or rationality, giving the previous religious statements the evaluation of describing an unchangeable innate incapacity on the part of women. To this effect, scholars such as the Shafi'i al-Mawardi argue that because women do not lead prayers and as a result forfeit the opportunity to lead the community at large, coupled with the fact their testimony is not accepted in the most serious of judicial cases, they must not be given the authority to make binding judgments at all, given that their judgments, under the Islamic paradigm, do not reach the levels of certainty nor serve the larger Muslim community in a positive way. Other scholars, such as the Imami scholar at Tusi, make use of sociological arguments in addition to the arguments of innate deficiency, which include the potential for temptation on the part of men who would have to endure consistent interactions with people of the opposite gender, a gender they find attractive, creating a problematic environment of fitna, or trial and tribulation. To substantiate this claim, Atusi uses the hadith which commands women to clap instead of speak when seeking to communicate with the imam of a prayer congregation, which differs from their male peers, who can in fact use their voices to communicate, under the reasoning that the male voice is not a form of temptation in such a sacred environment as prayer. He uses this commandment to problematize the female voice, which would be in great use if she served as a judge, judging numerous cases per day. The Shafi'i scholars of Shariah and al-Baghawi also hold the same view, under the same reasoning. Ibn Hazm, who took part in the growing debates during the 5th century, belonged to the Lahiri school of law, and as such differed with his peers and maintained the position that women can serve as judges. He permits women on the basis of the verse 458 of the Qur'an, which states, God ordered you to render your trust to those whom they are due, and when you judge between people, that you should judge with justice. Due to the fact that verses carry a gender-neutral tone, unless stated otherwise, Ibn Hazm uses this verse of the Qur'an to prove that in fact women can serve in capacities where they judge. Of course, this still leaves the hadith which explicitly bars women from positions of rulership, for which he states that this prevention is limited to the caliphate alone, and not all authority. He also uses a tradition which describes Umar ibn al-Khattab, the second caliph of Islam, and a close companion of the Prophet, and consequently a religious role model, placing a woman from his tribe in authority over the marketplace, a clear diversion from the claim that women are not suited for authoritative positions in the public and private spheres. As we have seen, classically, it was the majority opinion within Islamic law, maintained by the Shafi'i, Hanbali, and Maliki schools, that women may not serve as judges in any capacity, given that according to religious scripture, their appointments in positions of leadership would prove detrimental to the progression of a society, as well as be unsuitable on account of their deficient intellects. But we have come a long way since the 5th century of Islam. So how do these same legal texts hold weight in a climate where women play a greater role in the public sphere? In Muslim countries like Syria, Indonesia, Malaysia, Egypt, and Pakistan, we find that in the 20th and 21st century, women have begun to occupy positions as judges, some reaching even the high courts, a clear departure from classical precedent. Despite these advancements for women, this was not an easy road, and in Syria, for example, during the 1970s, the Syrian public was greatly opposed to the appointment of female judges, an appointment which took place shortly after, despite such pushback in 1975, when the Syrian government appointed Ghada Murad to the judiciary. It was only after her retirement that Murad pointed out the harsh opposition she faced during her appointment. Next, we will turn to the history of female judgeship in Malaysia, highlighting similar barriers to entry, the pathways to progress, and the dissenting voices along the way. The country of Malaysia is made up of 13 states and 3 federal territories, and contains a legal system based on common law, which was directly influenced by British colonization that ended in 1957. The Parliament of Malaysia enacts federal laws that apply throughout the country, though certain states enforce particular laws that are limited to that state alone. It also has a dual system of law containing both civil courts and Islamic Shariah courts, with the latter falling under the jurisdiction of the states as opposed to the federal government. The Shariah courts, under these jurisdictions, deal with personal status laws and ta'zir offenses, which do not include the hudud or qisas, and largely deal with family issues that some say are better suited for female judges. This centering on family issues of the Shariah courts has in fact been one of the key talking points for advocates of women appointment as judges in Shariah courts, despite Malaysia being a predominantly Shafi'i legal jurisdiction under Islamic law, a division of the Islamic legal system which, as mentioned earlier, is against the appointment of female judges in any capacity. Despite this fact, female judges were appointed to the lower civil courts as early as the 1960s, and the High Court in 1983, though their entrance into the Shariah courts did not happen until about a decade ago in 2010. Like their classical peers, scholars in Malaysia in 1982, forming the National Fatwa Committee, NFC, issued a fatwa prohibiting women from being appointed as judge based on the fact that they conceived of judgeship as equivalent to a leadership position, a position that, based on the reading of hadith, is not one suitable for women, at least for a community that wishes to progress. This fatwa was greatly influenced by the mid-20th century ruling by the well-known, predominant Egyptian Institute of Religious Education, Al-Azhar, that opined that major public posts are gender-specific and reserved for men only. In the 1990s, lawyers made complaints about the manner in which male judges issued rulings in family courts, largely in the case of custody disputes. This led to an influx of media attention which urged the appointment of female judges to Shariah courts on the basis that it became a necessary component of facilitating justice for the Malaysian public. It was these complaints, coupled with the work of other legal professionals and female-oriented NGOs in Malaysia, that led to another fatwa from the NFC in 2006, which announced that qualified women may be appointed as Shariah court judges, in other words, determining appointment on the basis of one's qualifications and not one's assigned gender. A great departure from the dominant opinion in Sunni Islamic jurisprudential discourse, where male gender was a prerequisite for the position. Though, as mentioned earlier, states have the authority to issue legislation for their own jurisdiction, and states must also agree with this fatwa and implement it in their own regions for this new change to take root. To this effect, the federal territories passed the same fatwa in 2007, while the states of Kelantan, Sarawak, and Kedah have declared an adamant disapproval, with other states remaining silent on the issue after the initial fatwa. This reluctance can be said to be influenced by key players in public opinion as it relates to religious issues. For example, although the NFC departed from classical opinions on the matter, others, such as the 2007 Chief Shariah Court Judge of the Malaysian Shariah Courts, still disapproved of female judgeship, citing several authorities from classical formulations of Islamic law within the Shafi'i school. He opined that women can serve positions other than judge, such as research officers, but judgeship he considered to be too complex for women to handle, which may stem from the hadith articulating women's deficiency in intellect and prevention from positions of authority. All of this is despite the clear contradiction of such limitations based on gender with the spirit of Article 8 of the Malaysian Constitution of 1957, which prohibits discrimination on the basis of gender. As of late, other states have joined those who have previously endorsed female appointment, with states such as Malacca, Perlis, and Pahang appointing qualified female candidates to judicial posts in the Shariah courts in 2012, as well as the state of Selangor appointing 2 female judges in 2016. Although they have contradicted classical opinions by these appointments, the states mentioned have not issued a fatwa to substantiate these changes from an Islamic legal point of view, which may highlight an adherence to classical thought by the state's scholarly class, or an inability to substantiate current decisions in light of orthodox scriptural and legal interpretations of their dominant school. As we have seen, the appointment of female judges has faced much opposition, with traditional and scriptural precedent from opponents of other minority views permitting the practice. This opposition stems largely from hadith and Quranic verses, which, if taken literally, do not speak highly of women's appointment in positions of authority. Some modern religious authorities have reinterpreted these traditions, such as the tradition detailing the female deficiency in intellect, to imply that rather than a deficient intellect in regards to reasoning or intelligence, it speaks to women's obvious heightened emotionality in comparison to their male peers. Though I question whether this interpretation really makes sense, because the hadith used as a proof for women's deficiency clearly outlines the reasoning for this deficiency, and uses the Quranic verse commanding that 2 women witnesses stand in the place of 1 man on the issue of financial legal contracts. How can it be that one's emotionality would play any role in the witnessing to a financial contract? Also, other modern scholars opine that the reason behind 2 witnesses equating to 1 male is on account of their lack of knowledge and engagement in public life, specifically the area of finances. But then why would the hadith explicitly state the reasoning behind this was their deficiency in intellect? Although whether the scriptural justification for such appointment is necessary is a question that may not be deemed relevant, since, as we have seen, the appointment of female judges in Malaysia, in some states, was not the result of a change in religious attitudes, as evidenced by the lack of fatwas endorsing female judgeship. Though the Hanafi, Zahiri, and Jabari schools have taken the view that women can be appointed as judges for civil matters, does this represent an adherence to the spirit of the law as evidenced by religious texts? Also, how do these interpretations fare in countries dominated by one of these particular schools? Egypt, for example, which was traditionally under the Ottoman Empire, which adhered to the Hanafi conception of Islamic law, during the battle of female appointment, chose to adhere to the more restrictive opinions within the Islamic tradition, which prohibited the appointment of female judges, despite the precedent in the Hanafi tradition. The administrative court acknowledged that there existed differing opinions, but reserved the right for the state council to decide and select which doctrine it found most suited to the condition of women at any particular historical juncture. Due to the work of civil society activists, such as the Alliance of Arab Women, the Egyptian Center for Women's Rights, and the Center for Independence of the Judiciary, Egypt has since appointed numerous women to the position of judge, with the first appointment made to the High Judicial Court by presidential decree in 2003. Given that the prophetic traditions and Quranic injunctions have remained the same, and differing opinions existed on the issue since the formative period of Islamic law, it leaves the door open for the appointment of female judges in Muslim societies and facilitates a path towards gender equality in the public sphere, an ongoing battle for proponents of women's rights. Perhaps, as time goes on, more conservative religious groups holding views that are not in favor of women's appointment will be able to see that the position of judge is not so complex after all for the female mind. So that comes to the end of my video on female Muslim judges in both pre-modern times and the modern period, with a focus on the case study of Malaysia. If you enjoyed this video, please do consider liking and subscribing. This has been the religious inquiry of female judges in Islamic law, and I will see you in the next video. Take care.